Guy Lawton, the law guy here. Today I want to talk to you about a United States legal concept called the Sony Rule. But first, a little bit of background. In the US, there are three main ways that an intermediary can be found liable. First, contributory infringement. Secondly, vicarious liability. And the third and more modern development is something called inducement. In the 1970s, Sony developed technology called the Betamax videotape recorder. Universal Studios and Walt Disney then took them to court, arguing that they were indirectly liable for the primary infringements of the consumers who used that system to record copyright owned by Universal Studios and Walt Disney. The Supreme Court did not hold Sony liable, and in their reasoning, something called the Sony Rule was born. They drew an analogy with the Patents Act staple article of commerce doctrine in determining this new rule. They said, accordingly, the sale of copying equipment, like the sale of other articles of commerce, does not constitute contributory infringement if the product is widely used for legitimate, unobjectionable purposes. Indeed, it need merely be capable of substantial non-infringing uses. They didn't develop too much on how to determine if something was a substantially non-infringing use, because they felt, however it was to be interpreted, the one plain and simple primary use of time shifting would meet the standard and threshold. The Sony Rule is a pretty reasonable doctrine when you think about it. It would be strange to hold a battery salesman liable for the act of a third party who uses that battery for nefarious purposes, like creating a bomb or an explosive. The Sony Rule balances the competing interests of copyright holders and technological innovation. If we did hold the battery maker liable, it would deter future developments of technology, as a third-party use of a product in a way that it was never intended to be used could amount to liability. However, if we don't enforce copyright, there'll be no incentive to create copyright material, as it won't be financially beneficial to do so. So how does the Sony Rule apply now in this online world? Napster developed one of the first peer-to-peer networks that allowed users to download music in an MP3 format in A&M Records and Napster. The courts distinguished the Sony case as the use of a centralized server provided Napster with knowledge of the infringement and also the ability to control the infringement. The courts also stated that the Sony Rule only applies to contributory infringement. In MGM Studios and Groskter, the courts further narrowed the application of the Sony Rule. The courts held the Sony Rule would have precluded Groskter from liability had the evidence been limited to just the characteristics of the product. That due to the lack of a centralized server, Groskter the developer did not have any knowledge of the consumer's infringing use. But the evidence showed that Groskter induced the consumers to use his product for infringing purposes, resulting in the courts finding him liable. So if you're looking to develop some new technology, like the iPod, or some new software for peer-to-peer file transferring, the Sony Rule will protect you from contributory infringement as long as the non-infringing use is substantial. Even if you do recognize that users could use your product for infringing uses, just as long as you don't have actual knowledge or constructive knowledge, and or that you don't induce consumers to use your product for infringing reasons. By doing so, you leave the boundaries of the Sony Rule, and the test won't be able to protect you from liability.